Well, good evening, and welcome to this program, The Origins of Oregon's Psilocybin Services Act with Kathryn Tucker. I'm Laurel Westendorf. I'm part of the Community Relations team at the Deschutes Public Library. Every month we explore a theme in our programming, and this month's theme is Origins. You can find more of our free library programming on our event calendar at deschuteslibrary.org/calendar, or you can find recordings of programs like this one on our YouTube channel. Our presenter is Kathryn Tucker. She is Special Counsel at Emerge Law Group, where she co-chairs the Psychedelic Practice Group. Thank you so much, Kathryn, for talking to us tonight about Oregon's pioneering law on psilocybin access.
Thanks so much for having me, and thanks to everyone who's able to join. So yes, we're going to dive right in, and I will try to save time for questions. So please do post them, no question too small or large. So I'll introduce myself. Let me see here if I can advance my slides. So I can't seem to advance the slide. There we go. I'll spend just a minute introducing myself. I'm a lawyer. I am now in practice with Emerge Law Group, where I co-chair the Psychedelic Practice Group. I'm a founding board member of the Psychedelic Bar Association. And my career of now more than 30 years has been in advocacy to protect and expand the rights of terminally ill patients. And so I'll be talking about that population in particular during this talk. But of course, the enactment affects many other populations as well. Across my career, I can say that there has been a lot of work and a lot of progress in improving end-of-life care. And that would include improved pain and symptom management, expanding choices available to patients with terminal illness, including more aggressive pain management, including the intervention known as palliative sedation, including the intervention known as aid in dying, sometimes also referred to as death with dignity. But one of the things that really caught my interest were the emerging studies showing the remarkable efficacy of psilocybin therapy to address non-physical suffering. And that is a really important new tool to be able to put into the palliative care toolbox. So that's where my interest in psychedelic medicine really was piqued. And a lot of my current work is in this domain. So, this question about how can this important drug be accessible for various purposes, it brings up the question of legalization. And so, of course, as you know, Oregon voters through the initiative process were presented with Measure 109, a citizen initiative measure. And that was on the ballot in the fall of 2020. And even though, it was the height of the pandemic, or the pandemic was very concerning at the time, and it was necessary to gather signatures, which is normally something that happens in person in public spaces, it was possible to get enough signatures to get this measure on the ballot, which was quite remarkable. And then, even though it was the first time such a ballot measure had ever been presented to voters of a state, it succeeded. Also quite remarkable. And so Oregon has now stepped forward as a pioneer. Once again, it has done that several times in interesting health-related measures. And it's the first state in the nation to make legal access to psilocybin. And I'll talk at some length about the schedule, but the law does not become fully effective until a year from now. So our conversation is very timely because we are 1 year into the preparation and 1 year before implementation. So, why does it matter? You might ask yourself. Well, of course, as mentioned, if you are interested in relief of non-physical suffering in patients with serious illness, that application shows great promise as a valuable new tool. So certainly those communities are sitting up and taking notice. Are there other applications for psilocybin? Yes. I won't spend as much time talking about them tonight. I've given you this short list of other realities where human suffering can be alleviated through psilocybin therapy. And that includes relief of PTSD. And that's been shown especially dramatic in the treatment of veterans suffering PTSD. It's also been shown to bring relief to substance abuse disorder, eating disorders, and it also is understood to have a range of interesting utility for the so-called healthy normal. I will just pause here and mention, and of course, everyone in this audience is a big reader because you're attending a library program. And I believe Laurel has put together a bibliography of library materials that bear on our topic tonight. And one that I do recommend and really found quite enjoyable, if you haven't read it yet, is Michael Pollan's book, How to Change Your Mind. And so I hope you'll pick it up and read it and share it and discuss it if you haven't already. So coming back to the reality of the patient population that I serve, for all the wonders of modern medicine, one of the challenges is it does such a good job at staving off death that now sometimes the dying process can be a very prolonged process. And this quote from Atul Gawande, and many of you may have also read his book called On Being Mortal. Very excellent book. He's the medical correspondent to the New Yorker magazine. He has recognized that in his work. And this long medical struggle, it can be brutal. And for those of you that may be clinicians or who have yourself or family encountered these conditions I've listed here, these are common burdens imposed by these different illnesses. And it can be quite an overwhelming cumulative burden for a patient in their evolution with terminal illness. And there has really been this wonderful progress that I alluded to over the last 30 years in improving end-of-life care as regards relief of physical suffering. So tremendous strides forward for improving pain and symptom management, encouraging enrollment in hospice, expanded access to hospice care. And so that's all really wonderful. And yet modalities for relief of non-physical suffering have not seen as much expansion. And so that's why these findings, which I'll talk a bit about, are so exciting and compelling. And so here are some of the studies. These can all be pulled up online. These are the actual reports of different trials. So they're very heavily oriented to a medical reader, but they are still accessible. And if you're interested, I encourage you to take a look at them, finding that when guided psilocybin therapy was provided to cancer patients suffering anxiety, there was significant and sustained relief. That's a big deal. Here's another study, this one out of NYU, immediate, substantial, and sustained improvements in anxiety and depression, and overall improved quality of life. That is really significant. So I also like to pause and remind an audience to think about controlled substances are used, of course, in end-of-life care, that acronym EOL referring to end of life. And they can legally be used to eradicate consciousness, and that's the intervention known as palliative sedation. where a patient with physical suffering is sedated to unconsciousness. So there's no continuing awareness of physical suffering. Food and fluid are withheld until death arrives. We also, in many states, including another pioneering state measure in Oregon, also adopted by Citizen Initiative, was Oregon's Death with Dignity Act, now modeled in 10 additional states, where patients with terminal illness are able to access controlled substances to precipitate death to avoid further suffering. That intervention also referred to as aid in dying. So when we allow these choices to eradicate consciousness and to precipitate death, I think it's worth pausing and wondering, shouldn't there be access to this controlled substance to elevate and expand consciousness, which is what is seen to occur in those who ingest psilocybin? I think there's also a really interesting question, which Oregon will now be able to conduct exploration into when the Psilocybin Services Act begins to be implemented, is whether a patient with terminal illness who expresses interest in aid in dying, who has psilocybin therapy, would see that interest impacted in any direction or impact on other end-of-life options. Really interesting question that some early conversations about how to create study and examination of that are just getting underway. So because of these studies showing the efficacy of psilocybin therapy in relieving anxiety and depression in patients with advanced illness, we are now seeing many of the thought leaders in the hospice and palliative care community speak out in support of ensuring that access to this substance is available. And this is Ira Byock, who has this published in both the Oxford Handbook of Death and Dying and in this article I've cited for you in the Journal of Palliative Medicine. Byock is a former past president of the American Academy of Hospice and Palliative Medicine and quite a thought leader. Yeah, so I spoke to this slide just a moment ago. I do think that's a really interesting question. Yes. So psilocybin, as you may or may not know, is a substance that has been placed on Schedule 1 of the Federal Controlled Substances Act. Schedule 1 is the most strictly regulated of the 5 schedules, and it deems the substance to have no currently accepted medical use. If one is involved with the manufacture, distribution, dispensing, possession of a Schedule 1 substance, there are serious penalties, including possible significant jail time, large fines. If you are a registrant with the DEA because you are, for example, someone who prescribes controlled substances in your practice of medicine, you could be at risk of revocation of your DEA registration. So what are the options then for access to a Schedule 1 substance, psilocybin? Well, sort of the main avenue would be to remove psilocybin from Schedule 1 and to reschedule it to a lower schedule. That, of course, is really the objective of the ongoing clinical trials that are later stage trials, at the end of which would be a normal time, assuming safety and efficacy had been established through the trials, to see a rescheduling. It could happen earlier. There are some who advocate for rescheduling now, but it's more likely to come at the conclusion of the clinical trials. The FDA runs what's referred to as an expanded access program. That is an avenue to access investigational drugs. One of the things I'll talk about later this evening is accessing investigational drugs under right to try laws. Those are more recent laws that were really enacted with the view that the existing expanded access was not sufficient. So query how effective expanded access is in opening access. And then, of course, what the Oregon Psilocybin Services Act will bring into focus is this third bullet, whether what lawyers would refer to as cooperative federalism will emerge with the federal enforcement authorities, the DEA and the DOJ, choosing to respect the decision of states which have legalized access to the substance and created a regulatory framework. And that avenue, we don't yet know if that is going to emerge. So, as you may know, if you've paid attention to the evolution of the state-federal interface with regard to cannabis, which is also a substance that sits on Schedule 1 of the Controlled Substances Act. What happened over time was that a position was taken at the United States Department of Justice that if a state had made legal and regulated, the federal government would refrain from prosecuting conduct made affirmatively legal under state law. That became articulated in memoranda issued by the US DOJ. One thing I will say about that, and of course we witnessed it in the cannabis context, is that articulated policy can change with a change in DOJ leadership. So it may not feel like a very reliable safe harbor. So let's talk about legalization in Oregon under what is now referred to as the Oregon Psilocybin Services Act. So this is a statute that's very long, it's very heavily regulatory. It was principally drafted by my colleague at Emerge Law Group, Dave Kopelak. So he has a very deep knowledge of the nit and grit of the enactment. And I'm going to kind of go over the main points. So it is a regulatory framework. The Oregon Health Authority is going to be the implementing agency of the state. The statute sets up a psilocybin advisory board, and I'll talk a bit about that. But that board is already hard at work and has been for about a year, doing a lot of the preparation for implementation. We do have a psilocybin advisory board member who lives in Bend, who is a hospice and palliative care nurse. And then there are, I believe, 16 other members. Psilocybin services will be available to Oregonians who are 21 years of age and older. There is no medical diagnosis requirement, so it is an adult use regulatory scheme. The purchase, consumption, and experience with psilocybin is to happen only at a licensed service center under the supervision of a licensed facilitator and after the completion of a preparation session. There will not be homegrown psilocybin, so the manufacturer is one of the licenses that will be licensed, issued by the state. So those who want to be in the business of manufacturing psilocybin, whether through growing the mushroom or synthetically, those will apply for a manufacturer license. There will be licenses issued to service centers to operate the center where the psilocybin therapy will be provided, psilocybin services, and there will be licenses for facilitators. I mean, interestingly, the facilitators need have no education beyond a high school education and whatever module of training the OHA determines as necessary. And that's part of what's being developed now. But you need not be a college graduate. You need not be a social worker, a therapist, a physician, a psychiatrist. You don't need to hold those advanced degrees, which is an interesting aspect of this law. And there will be laboratory licenses as well. So the OHA will be setting out these application forms and the process and conducting background checks and then issuing, suspending, revoking, renewing the licenses. Various restrictions on how many licenses can be held. It is possible to both have a manufacturer license at the same premises as a service center operator license. The manufacturers and service centers requirements about ownership among Oregon residents and other residents requirements. So for those interested, it's important to know this and plan ahead so that you have the sufficient residency for the license that you would be planning on applying for. So the services to be provided by the facilitator, as mentioned, really modest sort of requirements to become a facilitator, and modest requirements to be a client. No medical precondition, no medical diagnosis required, just adult. And the services are meant to be provided in a preparation session, and then an administration session, and then an integration session is to be offered. It is not mandatory, but of course, that is often seen by those involved with psilocybin therapy as the most important piece of it. So various requirements, as I say, heavily regulatory. One of the interesting things about the way the statute is written with the mandate that psilocybin services occur only at a psilocybin service center is whether that creates an impediment, a barrier to access to those who may have serious illness or other disability that would make it difficult, if not impossible, to visit a service center. One of the things that I'll just mention that I think is quite interesting is, of course, when Oregon's law passed, it became of considerable interest to other states. And our neighbor to the north, the state of Washington, has just seen the introduction of a bill modeled very much like the Oregon bill, but with an exception for this population of those who have serious illness, making visit to a service center undesirable. So that's a really interesting, I would say, improvement in this next generation. So that's the administration and integration section. Here's a little bit of the background. And these slides I'm going to, of course, make available. So don't feel you have to memorize everything. I'll make sure they're available to everyone who wants them. Details about manufacturing, some of the details about the service centers, limitations on advertising. I'm not going to go through all of that. So here we are in the flow of the events from January 2021 through December 2022, the end of this year. This is the preparation for this heavily regulatory framework. And the OHA is busily at work through the Psilocybin Advisory Board to collect and publish studies that bear on psilocybin, and to begin the process of rule development and adoption. So the Psilocybin Advisory Board has been making all of these preparations. They've been holding lots and lots of meetings, and the meetings are all open to the public, and you can listen in to them. There are public comment periods. I believe one is open right now. There will be rules proposed and rule comment periods. So all of that work is now well underway. Here is your Psilocybin Advisory Board with the composition sort of by category of the various specialists on the board. And the implementation timeline in a graphic, so you can kind of get a sense of the major milestones. So that, and of course, I hope we'll have a chance to drill down into some discussion in the Q&A. That is the Oregon Psilocybin Services Act in a nutshell, or landscape overview. I do want to flag for people interested in this that there's another effort underway to utilize existing federal and state law to open access to psilocybin under what are called right to try laws. So, you know, as I mentioned in talking about the Oregon Psilocybin Services Act, one of the unknown questions is whether the federal government will allow the Oregon statute to operate, or whether it will try to thwart and punish those involved. So in the interest of finding a federal safe harbor, I took a deep dive into whether right to try laws might provide both state and federal safe harbor for access to psilocybin for at least a particular population. So if you don't know about right to try laws, they are quite recent. The first state enactments began in 2015, and in the intervening 5 or 6 years, 41 states have adopted them, including Oregon, and including Washington State, which I'll talk about a little bit because of an advocacy effort that's underway there. The idea of right to try laws is that for patients with terminal illness, they don't have the time to wait for the long, slow process of new drug approval to wend its way to completion. And there's an urgency to their need. So what the statutes say is that if an investigational drug which is otherwise prohibited because not yet approved, if it has passed a phase 1 clinical trial, it can be accessible to patients with advanced illness. And so I've given you the quote to the Washington statute and to the federal statute. And you might be wondering whether the right to try includes Schedule I substances. And the answer to that, I believe, is yes, because we know what a carve out or an exclusion of Schedule I substances looks like, because several states, and I've given you here the example of Missouri, in their right to try statutes, specifically exclude Schedule I substances. The state of Washington, the state of Oregon, in contrast, have no such exclusion. So again, this would be for patients that have life-threatening disease or condition, who have exhausted approved treatment options are unable to participate in a clinical trial involving the eligible investigational drug and who execute a written informed consent. The eligible investigational drug is any drug which has completed an FDA approved phase 1 clinical trial and is not yet approved for any use and remains under investigation. And I've put those little red check marks to indicate that that is the fact, is the case with regard to psilocybin. So it meets the definition of an eligible investigational drug. So we did approach the DEA about a year ago to inquire how it would accommodate the right to try, which is duly enacted state and federal law. And the DEA indicated that it would not accommodate the right to try. And so that opened the courthouse door to a court to consider the matter. And so this case, which is now known as Ames et al. Versus DEA, is in the federal courts. I've given you a link to a Seattle Times article talking about the case. The involved clinician is a palliative care physician in Seattle area, and he has an integrative oncology institute called the Advanced Integrative Medical Science Institute, AIMS. And so they are the petitioners or the plaintiffs in this case, along with some of the cancer patients who want access to psilocybin therapy. When we took that case into the court, there was a lot of public interest in it, including 8 states, including the state of Oregon, coming forward to file an amicus brief, also known as a friend of the court brief, to express their concern that the DEA was thwarting the operation of state law, and in particular as regards a medical practice, which the states are very protective of. Just this week, you may have seen some media coverage of the fact that federal elected officials have now reached out to the DEA to encourage it to negotiate resolution of the case in an effort that was led by Oregon's Representative Earl Blumenauer. And so it is possible that before the court rules that the DEA could come to the settlement table and negotiate resolution. I like to say that the DEA, full disclosure, I represent the petitioners, so I speak from that perspective. I believe the DEA ought accommodate the right to try. It is the law of the land. And let's remember the DEA's scope of authority is to effectuate controls against diversion. That is the task of that federal agency. It does not make determinations regarding the practice of medicine. We know that quite well from a really interesting case that I was also involved with, known as Oregon versus Ashcroft Gonzalez. And those of you may recall that when John Ashcroft was U.S. Attorney and then succeeded by Alberto Gonzalez, the position was taken that any physician in Oregon who participated in the Oregon Death with Dignity Act could be deemed in violation of the Federal Controlled Substances Act and punished and have their DEA registration revoked, among other sanctions. That case went through the federal courts, and at every level, including at the Supreme Court level, the ruling was that the DEA is not empowered to make any determinations about the practice of medicine, and that in fact it is the states that are the primary regulators of the practice of medicine. So I think that is the right outcome here, but the matter is now in the hands of the Ninth Circuit Court of Appeals. And of course, if that court, regardless how that court rules, it is a matter that could be petitioned for review to the United States Supreme Court, and it may be that review at that level and decision at that level will be necessary. But what I like to say, and just going back to this slide, DEA has a large toolbox of tools that it could use to accommodate RTT. It could create an RTT registration. It could adopt waiver for RTT compliant conduct. It could issue exemption or exception. So it has a multitude of ways in which it could accommodate right to try and still ensure that its interest and concern in ensuring safety from diversion would be addressed. So I hope that that's what will happen. We, of course, do not know. So before I open to your questions and discussion, I would say that interest in psychedelic substances for a variety of uses is burgeoning. There's just a tremendous excitement. I think Michael Pollan's book helps us understand why that is so, because there are so many different mental health challenges that are mitigated and ameliorated with these different substances. And we are in a time, even pre-COVID, but especially deep into a worldwide pandemic, dealing with a lot of different kinds of mental health challenges. So new tools for addressing those challenges are of keen interest. Oregon is once again pioneering innovative policy, and it is very much closely watched by the rest of the country. And when you go to national psychedelics conferences, a lot of discussion is had about the Oregon enactment. And I would say the nation is watching what will be unfolding here in Oregon very, very closely. And already, as mentioned, we are seeing other states starting to follow in the Oregon footstep, and Washington is a really good example of that. 1 year from now, literally January 2023, the psilocybin services are to be available in Oregon. So I guess I would say for any of you listening who are intending to seek any of those types of licensure, advanced planning, now's a really good time to be thinking about how to get yourself prepared to submit an application for licensure under this program. So that is really the conclusion of my formal remarks, and I'd be really delighted to engage discussion with anyone who has questions, comments, observations, etc.
All right, Kathryn, we already have quite a few questions. The first one I'd start with is, why would federal law schedule psilocybin as a Schedule I drug?
Well, again, I invite you to pick up Michael Pollan's book. There's such a huge backstory here. In the 50s, the 1950s and the 1960s, there was a tremendous amount of research with psychedelic substances. And that research was shut down with the advent of the war on drugs by the federal government. And there were a lot of contributing factors. It's a really interesting and complicated story. You may also enjoy the book called The Harvard Psychedelics Club, which is another look at what happened. So many of the studies were coming out of Harvard at the time, and the protocols for those studies would be seen as not very rigorous by today's standards. And I think, they came under considerable question. And suddenly all of those substances were moved to Schedule 1, and research basically stopped. And it wasn't until the intrepid modern day researchers in the last 15 years or so got back in the trenches with applications to research and begin these much more rigorous and carefully controlled trials. But there's a long, deep backstory on why these substances were all suddenly moved to Schedule 1 and have sat there for so long.
And then we have a question that's particular about hospice. It's a little bit longer. Will it really be possible for hospices to participate under Measure 109 since they are so dependent on Medicare and Medicaid, and psilocybin is still federally illegal?
Yeah.
Many hospices say they cannot legally prescribe medical marijuana because it remains a Schedule 1 controlled substance under federal law.
Yes. Yes. So that's a huge open question, because on the one hand, we see this really valuable application to that population of patients. Hospice patients could stand to really benefit. And yet, hospice is a federal benefit under Medicare. So how these services can be provided to that population remains to be seen. Now, of course, many patients with terminal illness who may be enrolled in hospice may have the ability to visit a service center. And so that population can have their needs addressed under the normal workings of the statute. The difficulty comes for the fraction of those patients for whom making such a visit is not recommended or possible. And then the question is, can there be a reasonable accommodation, a reasonable modification of the statute for those patients so that they're able to enjoy the benefit of the statute? And that, through a disability rights lens, would seem to require that kind of modification, because it's not permissible for a state to adopt a program that benefits residents of that state and discriminate against those who have disability that creates barrier to access. So that's an open question.
I'm reading many different questions here. They're great questions. Do we know yet if Oregon will be providing assistance to small businesses navigating legally or fiscally this new market?
Oh, interesting. I don't know the answer to that question. One thing I should mention for people who are interested in this, Dave Kopelak, who I mentioned, is my colleague at Emerge Law Group, who was the principal drafter of the law. He's just about to start a webinar series called something like A Deep Dive into Measure 109. And these are going to be monthly webinars that are free and open to the public. And so if you are interested, and particularly, on these sort of drill down business questions, Dave, who is a business lawyer, would, I think, be a really excellent resource. And there'll be the opportunity for questions in that webinar series. So check that out. I think you can go online to the Emerge Law Group blog and see an announcement about this webinar series. And please feel free to join.
I've had there's quite a few questions about the educational requirements for facilitators and concern about that is not as maybe robust as some people might expect. Do you know why that decision was made?
Yeah. So I think that the initial sponsors of the measure Tom and Cherie Eckert, who are both therapists themselves. When they conceived the idea of this measure, I believe they wanted to have as few sort of barriers to participation as possible. And that's true on the facilitator side, and it's true on the client side. And that's why you see these, very minor barriers to access or to providing services. One of the main areas of work for the Psilocybin Advisory Board and for the OHA will be determining what education to mandate for the facilitators and what the examination will be to licensed facilitators. So there's a huge amount of discussion going on about that. And there's also just an enormous proliferation of different vendors offering different training programs. So I think what we're going to see is a very broad range of offerings for the trainings. And when we know what will be required by the OHA, it will become clear which of the offerings are going to meet what is required. And then those interested in a facilitator license can choose among them. I think also because certain populations, such as patients with serious advanced illness, would present a medically complicated and fragile situation, it is likely that certain facilitators will specialize in meeting the needs of special populations, and they may well hold more advanced education and credentials. Having said that, again, the sort of threading the needle to avoid putting a registration with the DEA at risk, if you are a licensed physician, for example, is going to be something that will need careful attention.
And there was a clarification about whether if the right to try law went through in Washington, would it be for Washington only or all states?
Yeah, so the pending case that was started in the state of Washington is presenting the Federal Circuit Court of Appeal with a question of first impression about whether the DEA must accommodate state and federal right to try law. The ruling of that court will certainly apply to all the states in the Ninth Circuit, which includes Oregon, among many other states. But it will be the first and only federal appellate ruling on the duty of the DEA to accommodate RTT. And so it would certainly have at least persuasive authority nationwide. So bottom line, if the court finds in favor of petitioners, it should lead to access to psilocybin therapy for the eligible population of patients in any state that has adopted a right to try law that doesn't carve out Schedule I substances, like Missouri, for example. Although I will say about Missouri, as I noticed just last week, there is an amendment in the Missouri legislature to eliminate the Schedule I carve out. So that may happen there.
And there are quite a few folks asking how to become a facilitator. Where is the link for the application for this facilitator license? Do those things exist now, or is it still waiting?
Yeah, it's still waiting. So, the work of the Psilocybin Advisory Board is still underway. And that work will be informing what the Oregon Health Authority does. And so we're soon to be moving into a proposed rule making So I would invite anyone who wants to follow and track this really closely to also go online to the OHA, the Oregon Health Authority, psilocybin services, and enroll yourself, put your email in for updates and notices, and they will populate your inbox with notices about everything that's happening. They are assiduously public about all of the meetings and discussions. And so there is opportunity to be in those meetings, to listen to the discussion, and participate in some of these discussions as well. And there is, as I think I mentioned right now, an open sort of community and public survey that the OHA is inviting anyone to fill out and send in. So you can find information about that on the website as well, the OHA website.
I'm not sure if this falls under the more nitty-gritty business question, but is the intention to manufacture within the state to avoid exposure to FDA and laws that apply to interstate commerce?
I'm not sure if I understand the question. I think, yes, I mean, just the idea is that the psilocybin would be manufactured in the state and consumed in the state under the statute, that there wouldn't be interstate commerce in psilocybin. And the protection that the state statute provides can only be state law protection. And as mentioned, the exposure to potential federal law sanction is a question that we don't know what that's going to look like yet. We don't know if there will be a position taken by US DOJ, as there eventually was with cannabis, to not use federal enforcement authority when a state has legalized. That's an open question. That is, discussion also for the state of Oregon to take up with, as a state sovereign with the federal sovereign and work that out.
And I do want to let everyone know that the recording for this will be sent out to everyone who registered for this program, as well as the resources that Kathryn compiled. And we'll try to get the PowerPoint slides out to everyone as well, because we've had a few requests for those. So I'll just ask one more question here. What misinformation would you be worried people assume about Measure 109?
Well, I mean, the fact that it was adopted with very strong public support suggests to me that Oregonians are fairly well informed about it. The campaign that was run was an education campaign. It was really to help people across the state understand what the benefits of this drug are and the populations that it can serve, and to help people understand that the trials that have been completed to date show that it is not a drug that leads to substance abuse problems. And in fact, it is a drug which can mitigate substance abuse disorder, along with a number of other serious mental health challenges. So I think the campaign did a good job. I think Oregonians became sufficiently educated to understand that. And so I hope that as the program unfolds, with all of the care that is going into this 2-year preparation, that when implementation begins a year from now, it will be able to go forward smoothly. And of course, it is a first of its kind law, and no doubt there will be some challenges, but I think everyone is really committed to an intent to see this roll out smoothly as a model for the closely watching nation, which it is. And Laurel, do you want to say something about, were you able to pull some library resources together. And I know this wonderful library system here in Deschutes County has such a wealth of materials. I think you found quite a few. And do you have a little bibliography of sorts on this topic?
Yeah, so there is a bibliography that's attached to the catalog of the library when possible, so that Deschutes County residents can put a hold on it or go and check it out. And that link will be sent to everyone who registered. So
beautiful, beautiful. There's a lot on this. I mean, I think I mentioned a couple of titles. There are obviously other books. There are some really great films. Fantastic Fungi has a segment on discussing psilocybin utility for various medical conditions. Really recommend that film. So yeah, there's a lot of learning to be done here.
Yeah, well, and it's just started. Thank you so much for getting us the legal lay of the land, Kathryn. That was very informative, and I didn't even get to all the questions, so I thank you for bringing in questions, and I'm sorry if we didn't get to you, but
yeah, people can follow up with me. I think I gave my email, so feel free to just shoot me an email.
Okay, great. Well, have a great evening, everyone.
Thanks so much.
Bye.